speaker, and I have with me today workers' compensation specialist Deborah Mathern of Michael J. O'Connor and Associates. And
Hi,
Deborah's going to
Cindy.
help. Hi, how you doing?
Very well, thank you.
Good, good. Well, we did this. It was pretty easy last time, so you're not too nervous, right?
That's right.
That's good.
We'll see how that develops as this goes on, though.
That's right. Well, when it's live, things happen, but that's okay. It makes it more interesting. So what we're going to do is you were kind enough to give me a really good list of seven potential, maybe common mistakes that claimants sometimes make in their workers' compensation claims. So what I'm going to do is I'm going to feed you those one at a time because I'd like to hear you explain them, comment on them. So will that work okay?
That will work great.
Okay, so let's go ahead and start off with number one. And again, am I correct? These are common mistakes that claimants sometimes make in a workers' compensation claim.
Yes, our law firm, Michael J. O'Connor Associates, we represent claimants exclusively in workers' compensation cases. And through the years, we've seen different patterns of things that people can do that can, be an error or a mistake in their case.
Right, right. Okay, so here's the first one, Deborah. Not quickly reporting their injury or advising their employer of how serious that injury was.
Yes, Cindy, that's actually a big one because everything starts at the very beginning. And very often we'll talk to somebody and they'll say, well, I was injured a while back, but I didn't do anything about it. I thought that perhaps my symptoms would go away, or I thought maybe my employer would be upset with me that I had the injury. So they don't report it. But there are actually statutes of limitations and deadlines that have to be met, and an injury must be reported within 120 days.
Okay.
So once you report it, you can decide whether or not you're ever going to pursue it or pursue a case or any legal action. But if you don't report it within 120 days, you are forever precluded from ever pursuing that injury. So it's always better to be safe rather than sorry and report that injury. Also, everything's going to be fresh in your mind at that point. If you're trying to come back months after an injury to remember who was present at the time you were injured or remember exactly how something occurred, your memory obviously will be a little less good at that time than it might have been earlier. Yeah.
Deborah, do you find that sometimes when a claimant does not report that, is it a fear factor of some sort?
Often.
Okay.
Over and over. I will even have people who come in to me that have a very serious injury. I had a gentleman who came to an interview recently, could barely lift his arm to shake my hand. He had not yet reported his workers' comp injury because he was afraid of the reaction of the employer. Jobs are important. And if you like your job and it's a good job, of course you don't want to do anything to upset your employer. Yeah. However, you really have to protect yourself. Yeah. And so, again, that's why the law is there, to help you and make sure that you have benefits. You don't have to pursue it, but if you don't report it, you won't have the option. And should your injury become more serious in the future and you're unable to work, you would wish that you had gone back and reported that within the 120 days that are required or as soon as possible.
Right, right. Okay, let's go to the second one, trying to hide a past injury or an underlying medical condition. What about that one?
That's also one that I see over and over again. Often people will be under are under the misunderstanding that if they've ever had a symptom or an injury to that same body part in the past, that means they're precluded or would not be able to get workers' compensation. But that's not always the case. In Pennsylvania, under Pennsylvania workers' compensation law, if there's an aggravation of a condition that's already there or a worsening of that condition, it can still be considered a work injury. And it's always better to tell the truth because during the case and during litigation, they're going to get documents and they're going to find out everywhere and anywhere you've ever been. And you don't want to lose what's called your credibility with the judge, your believability out of fear that if you say, 5 years ago or 1 year ago, I had treatment to that same body part, you always want to be honest with it. And we can often still win your case, even if there has been a prior injury to the same body part or prior medical treatment to that, as long as there's been some type of a worsening and exacerbation and aggravation of that injury, which what they'll look at is the symptoms. Did the symptoms get worse?
Okay.
So it's always important to be truthful with your attorney. It's always important to be truthful with the judge. And you shouldn't have a fear. You should discuss it with the attorney because often you can still have a work injury if something was made worse,
Yeah.
from whatever the event was at work, or your work duties repetitive through nature, through time.
Right. Right. Yeah, that makes sense. Good advice. Okay, the third one, not seeking prompt or proper medical attention.
This goes along the same line as the first one with not reporting your injury. Um, you're always better off going to the doctor as soon as you can. That way, there's a record of what your symptoms were very early on. Again, a lot of people think they're going to shake it off or work it out,
Yeah.
and that things will go away. And that, but if you notice this is really not going away, it's better to have a record of what your symptoms were that are recorded by a doctor. Because again, you're going to be coming in as a person and saying, here's what I felt. But if it's actually recorded by a medical provider, that's great evidence in your case. Another reason is going into that doctor's office and having them record the symptoms or have studies done that can prove or show that you had this injury. That's also very important. And if you're waiting either a long time to treat initially, or you're going a long time between doctor visits, you've lost the opportunity to have a record of that recorded in the doctor's notes.
Yeah. Yeah. The next one is communicating with a nurse hired by the insurance company. And that's interesting to me because you would think you'd be able to communicate with a nurse that was trying to find any information, but that's not a good thing to do.
No.
Okay.
It's hard to say what I would rank number one as far as how often I'll see these mistakes, but this one's right up there. It's got to be at least, these top ones. Often when somebody has a workers' comp injury, especially if they're put on workers' compensation benefits, but even if they're not yet on, the insurance company in certain cases will highlight that case, and they will have a nurse who's hired, a vocational nurse, to follow the case and to try to control the cost of the medical benefits or the medical treatment. When somebody's injured and they hear from somebody, they're often under the impression, oh, this person is really there for me, which to some extent they are. But I always say to people, you have to think about this logically. Who's paying that person, and what is their ultimate goal? And so while they may be helpful in some ways, often some of the things that they are doing, for example, setting up your medical appointments, these are things you really should be doing on your own, choosing your own medical care with the advice of your family or your attorney or someone who is really 100% for you.
Yeah.
If there's someone who has the idea of cost efficiency in mind, that's not always in your best interest from a medical standpoint. Your goal is to get the best treatment you can and get better as quickly as possible. They're looking at, and often we'll hear the nurse will talk to the doctor after the appointment and say, wait, you're prescribing this expensive medication. Can't we try another one first? Before you have that medical test, can't we try something else? Like they sort of give their opinions, and it's with the goal of perhaps limiting the treatment or limiting the cost. That's not always in your best interest.
Right.
Another thing is that we'll often get to court and questions will be asked of our clients. For example, they'll say, well, wait a minute, you're saying that you're unable to work, but don't you have 2 dogs that you take care of? Or don't you ride a motorcycle? And the person will think, the only person I ever talked to that about was the nurse in the case who was hired by the company. So they were actually writing all of this down to share with them. And now it's sort of being presented, I'm having a conversation about my dogs, and I think it's just a friendly conversation, whereas it's being taken in the context of how can we look at this in a way that we can maybe find something that's not particularly helpful to that client. It's more helpful to the insurance company.
Yeah.
So if you go back to who's paying the person and what is their goal, when you think about that, it's not always the best idea to be communicating with that nurse.
So in other words, you cannot count on the insurance company to be on your side.
They're not, even if they give you wrong information, they're not always held responsible for it. So you really do need to, that's, one of the things we'll say to people is you really do need to get an attorney so that you have advice that is 100% in your favor. There's nobody looking to take what you're saying to turn it against you, but we're looking to try to help you and make sure that there's a fair outcome in your case.
Right. And that really leads to the fifth one, Deborah, because this one you said is a lot of claimants they sign documents without seeking legal advice, or they resign, retire, or voluntarily quit their job.
Yes. And again, I think a lot of people, right after they do it, this is the one they do it and they actually realize it was probably a mistake.
Yeah,
But they get caught up. Somebody puts documents in front of you and they say you
right.
should sign it, and you sign it. And later you think, I'm not sure if I should have done that. If you're having that feeling, it's probably a correct idea.
Yeah,
Very early on in the case, often you'll be presented with a lot of documents in your case, which again is, I say to people, right away, it's a good time to get an attorney, even before you start getting your workers' comp benefits, because again, we can help with what is appropriate, what's not appropriate. But often in the stack of other documents, there'll be what are called releases, where they will ask for authorizations for them to gather medical treatment about you. However, if you have a workers' compensation case, the funny thing is, they don't actually need that authorization in most cases, because if you have a case, the doctors send their records along with their bills. They're going to have access to the relevant workers' compensation documents anyway. So often when they're getting those documents signed, those releases, it's to look
yes,
to see what else do you have wrong with you, or was there anything other than the
oh,
work injury? So
right.
you're signing thinking it helps with your case, when the release is actually going to be used to try to see if there's documents out there that
Wow,
can stop them from paying you or limit
wow,
their
yeah,
exposure. The other thing about the releases, most of the ones that we see, Cindy, are that they're too broad. Why would someone need to see, everything dating back to high school if you're 50 years old? That's a little far. It should
right.
be for a certain number of years.
Yeah,
Or, if you've injured your elbow at work, why would anybody need to see anything and everything, including your OBGYN records if you're a female, or any other type of records?
right.
They really should be limited to
Yeah,
something more relevant to the workers' comp case.
yeah,
Often they don't have dates on them. So those could be, any date can be put on those
wow.
as well to search. And again, if they're already getting what's relevant to the workers' comp case, you really should have somebody who talks it over with you. Now, there are times when I feel it is absolutely appropriate to sign a release. For example, if you claim you have an elbow injury and you had one 2 years ago, I think they're entitled, they should get to look at those to see, is there really a new injury or worsening? So in those cases, you can talk it over with your attorney, and perhaps a mutual decision can be made that, yes, these are absolutely appropriate
Yeah,
documents.
yeah.
But just don't sign anything in front of you.
Yeah, Deborah, I'd like to do another broadcast with you if you're willing on tricks of the insurance company, because it sounds like they have quite a few tricks that kind of cause the claimant to stumble and ruin their own case.
Well, hey, they're doing their job, but
Yeah,
you have to just be cautious, because
yeah,
again, you know, their ultimate goal is that they don't want to hemorrhage money on a case. They want to try to
right.
control it as much as possible. So their job is to look for ways to stop the flow of money.
Yeah,
Quite
yeah,
frankly,
yeah,
in many cases. Now, their goal is to take care of people, and I think that not everything is a trick, but there certainly
right,
are some tactics that are used that are not beneficial to you if you've had a workers' compensation injury.
right,
And then the
right.
second part of that you mentioned was signing papers where you're resigning or retiring or voluntarily quitting your job. These can
Yes,
be fatal, meaning they can absolutely stop you from receiving workers' comp wage loss benefits. Because the idea of workers' comp is you're getting paid those benefits, um, and you would otherwise be working. So if you're resigning or quitting, or if you're filling out retirement paperwork, that means you would not be having any income. So that gives the insurance company then actions that they can take against you to try to stop those checks. So you want to talk to an attorney
okay,
before you make any decision on that, because again, you might otherwise sign something, or if you indicate you're resigning, retiring, um, you might sign something or take an action or speak to somebody saying, I'm intending to quit or resign or retire. And that could limit your receipt of money benefits in your case.
that makes sense. Yeah.
Big mistake. That's a big mistake.
Oh boy.
Yeah.
Number 6, not considering settlement before it is too late. I'm not sure what you mean by settlement.
Well, in workers' compensation cases, after someone has an injury, in most cases, I could probably say all, but you never want to say all as an attorney, but in most cases, those benefits do not continue until death or forever. They're usually for a certain time period, and
Okay.
we can't get into that in one broadcast, but normally
Right.
it wouldn't be forever. But often people have in their minds that they're upset, so they're thinking, more with emotion. But they're upset and they're thinking, I'm never going to release this company from their responsibility for my injury. But in workers' comp cases, there often comes a time when you need to be thinking of plan B, like settling with the workers' comp insurance carrier. There's a
Okay.
money value to your case because they're obligated to pay you wage loss benefits and medical benefits. So there's a financial value to that. And you can approach a workers' comp insurance company when the timing is right, and you can approach them to say, I would take X number of dollars and I will sign off and release you from the case, and that I will move on and either go back to work at a lighter duty job, or I'll move on and be on some other type of benefit, such as Social Security disability or something else. But often people will wait until things happen in their case that reduce that value.
Oh.
So you sometimes want to talk to an attorney about what about the timing and when I should approach the company. Sometimes they'll approach you first and say, are you interested in settling? And if you say no, be prepared, because their next step is going to be, well, what can we do? Maybe we should get surveillance on this person. Maybe we should look further into how to stop the benefits. And maybe we should get another independent medical examination. Maybe we should file a petition against them. And if some of those things hurt your case, then that can reduce the money value for settlement.
Okay.
So
Yeah.
sometimes people will say to me, years after someone's approached them about something, now I want to. And the insurance company might say, well, now we don't want to anymore. Things have changed. The tide has turned. We feel things are more in our favor now. So
Yeah.
you want to keep in close communication with your attorney about that, about
Yes.
the timing, about the events that are going on in your case, and whether there's a good reason now to consider it versus, waiting until the value goes down.
Yeah. Deborah, do you find that the average person is aware that it would be very helpful to them to have an attorney in a workers' compensation claim? Or do the majority of people try and just deal with it on their own?
There's both. I mean,
You
there's
see both?
both types of people. There are some people who
Yeah.
come to me right at the beginning. I would say that those cases tend to go that's the smoothest, the
Okay.
most smooth,
Yeah.
would go, is if somebody comes early on, they're getting treatment or getting recommendations for legal advice early on regarding where to treat medically, what to do legally in the case. But there are some people who they're almost cautious or fearful about getting an attorney. I think primarily they're worried about what it will cost. And
Yeah.
now workers' compensation in Pennsylvania is a contingent fee. So that
Okay.
means there's no hourly bill that's mailed to someone. So often a lot of the advice early on, there's not even a charge for it because we're not legally permitted to charge for anything hourly. In workers' compensation, it's a percentage. It's up to 20% by law. And then it's if we either obtain the benefits for a client, or if they have benefits already and they're stopped and we win or get those back for them, or if there's certain court proceedings that take place where they are trying to stop the checks and we're able to keep those going for them, or if we negotiate a settlement. And generally, it's not a surprise when the 20% is coming out, because it's something that's happened through court usually, and the judge
Right.
will ask that person, did you hire this attorney and do you understand they're going to get 20%? And they ask them to actually verify their signature on the fee agreement.
Okay.
So,
Yeah. Yeah.
but I think often people are fearful. Some of them have even had other types of cases that were not workers' comp in the past, where an attorney sent them a huge bill.
Yeah.
And so they're
Yeah.
afraid, or they're afraid that might happen in workers' comp, but it doesn't happen that way.
Yeah.
And again, if they have questions on that, call and ask. The consultation is free. We can talk to you about not just the case, but in how the money part of it works and how the attorney fee works.
Yeah. Yeah. Well, the last one, we're down to number 7 now, and that is not seeking legal advice from a specialist, a workers' compensation attorney, early in the case.
Right. In Pennsylvania now, we actually, there's a test that has been given that you can become certified to be a workers' compensation specialist. Both attorney Bill Kowalczyk and I at this office, fortunately, were able to take that test and become specialists in workers' compensation. And then also that word can be even used more generally, in that someone who just specializes and does a lot of workers' compensation benefits. Today, as the same as with doctors, as an attorney, sometimes you'll find attorneys who practice a little bit of family law, a little bit of real
Yes.
estate, a little bit of this, a little bit of that. But workers' compensation has become fairly involved.
Yeah.
And so it's sometimes hard if you have somebody who isn't really specializing in workers' comp and keeping up with all of that to be competitive for you and to effectively represent you in your workers' compensation case.
Yeah.
So we sometimes get cases where another attorney's had the case for months and then finally realize they're in over their head and they should now refer the client to somebody who's more of a specialist in workers' compensation.
Yeah.
Again, some of the things we see that are not done in the files, it's often better if you ask the attorney, what is your background? Since there is this test in Pennsylvania where you can become a workers' comp specialist, did you take that test? Did you qualify to call yourself a specialist?
Yeah. Yeah.
So again,
Well, Deborah,
rather safe than sorry. So.
Yeah, that's right. Well, now if someone does have questions and they want to reach your office, how can they do that, Deborah?
Well, today there's so many ways, but obviously telephone 570-874-3300,
Okay.
and then www.o'connorlaw.com. And that has all of our information on how to reach us.
Yes. Well, this has been really helpful.
O'Connor. I always tell people not
Yes.
ER,
Yes, that's good to point that out, OR at the end.
Yes.
Deborah, listen, thanks a lot for your time today. This is really valuable information, and I appreciate it.
Thank you, Cindy.
Okay, and to those that are watching either live or on replay, please, if you have questions, feel free to leave them in the comments section here, and we'll make sure we get them answered for you. Thanks, everybody. Thank you.
All right, bye-bye.
Bye-bye.